Hi, everyone. I'm Lori Shivitz. I'm a partner in McCarter and English's Intellectual Property and Information Technology Group. My practice focuses on helping brands with their protection, litigation, transactions, and also at promotion. So that leads me to today's talk, which is Advertising 101. And here we go. Here are the topics I'm going to talk with you about today. First, the tenets of advertising law, including claim substantiation, puffery, advertising to kids, and endorsements. Why advertising? First of all, it's the best way for you to get buzz for your new companies and to promote your brands. And it's important to talk about these different tips to avoid pitfalls, because challenges can come from many different directions. For example, at the federal level, the Federal Trade Commission can object to your advertisements. At the state level, attorneys general can file lawsuits to enforce consumer protection laws. Your competitors may also object to your advertising and sue you either at court or through the National Advertising Division of the Better Business Bureau. And even consumers could potentially file class action lawsuits involving your advertisements. For example, in California, there have been class action lawsuits involving made in the USA claims. If there is any takeaway from the next 30 or so minutes, this is the slide for it. These are the tenets of advertising law. First, advertising must be truthful. Second, it must not be deceptive. Third, all claims, whether they're expressed or implied, must be substantiated, and the level of substantiation required depends on the claim you present. And finally, all of these principles apply to all kinds of advertising across all different media. So that includes your traditional ads like in print or on TV or on the radio, as well as any advertising you do online and through social media. First, advertising must be truthful. So if you say a truthful claim, the truth shall set you free. Well, that's not necessarily the case, because literally true statements may still be considered misleading and could get you into trouble. So for example, a couple of years ago, Anheuser-Busch ran some advertisements against Miller's Coors to say that Coors Light had corn syrup used corn syrup in its product. Well, Coors Light did in fact use corn syrup, but it was only in the fermentation process. So the end beer, after the product was made, didn't have corn syrup. Coors Light objected, and there was a long litigation where at the end of the day, actually, Coors Light won in the Seventh Circuit, but it cost a lot of time and a lot of money to get to the end result. So a couple things for you to consider whether or not your literally truthful statements are misleading. First of all, is the statement that you're making a statement that you're making about a material fact? And also, is it likely to mislead a consumer? Your context of the ad matters. And to prove whether or not something is deceptive or misleading, you'll take a consumer perception survey. You might think that disclaimers can save the day. Well, in some cases, that can be true. And disclaimers may be needed to help prevent an ad from being misleading. But if you're making a false claim in the ad, you can't rely on your disclaimer to automatically or magically make it into a true claim. With respect to the disclaimers themselves, it's important that they appear clear and conspicuous, even though there's no particular font size or color that's required by law. You want to make sure that they're big enough, they're close enough to the claim that is being modified, and they're positioned in a place where consumers are likely to see it. In order to make a claim, any claim that in your advertising, you need to have substantiation. So that means you need to have proof or a reasonable basis that the claim that you're making is true. So here are some factors to consider when determining what constitutes a reasonable basis. The type of product. For example, a health product may require clinical trial in order to provide sufficient substantiation. The type of claim, a superiority claim, my product is 10% better than yours. Well, I better have done the necessary testing to show to consumers that yes, in fact, my product is 10% better than whatever I'm comparing my product to yours is true. And as well as the amount of substantiation experts in the field think is reasonable. So amount of substantiation for experts, if, for example, you're dealing with a pharmaceutical product, you may need a double-blind trial. If it's a different type of product, an industry standard approved test to prove your claim would suffice. You may have heard of the term puffery. So puffery is an obvious exaggeration, it's hyperbole, it's subjective, it can't be objectively quantified. As a result, puffery is not an actionable claim. Examples of puffery would include the best coffee in the world or the coolest presentation at Startup Boston, for example. If you make puffery statements, you don't need substantiation to make them. However, it is possible that statements may lose their quote unquote puffery status depending on their context in the advertisement. For example, a statement, the best tasting coffee ever, may be fine and considered puffery if it's standing alone, but if that statement's being used in the context of a comparative advertisement where the advertiser is comparing their coffee products to those of their competitors, then there may be an objective component that's introduced and the advertiser would no longer be able to rely on puffery to get around the claim. If you market to kids, one of the most important laws out there is the Children's Online Privacy Protection Act, or COPPA for short. So it's been around since 1998, so nearly 25 years. And the purpose is to limit the collection of personally identifiable information online from kids who are under 13 without their parents' consent. So if your service, if you have an online service, a website or an app that's directed to kids who are 12 and under, and you collect or maintain personal information from kids 12 and under, there's certain things that you need to do. So first of all, is your online service directed to children under 13? So here are some factors to consider. The subject matter of the site. What are you selling? Is it something that kids would like? Is it something that kids participate in? Does it have advertisements that are directed to kids? What do visitors to your site or app see when they come to it? Do they see animated characters like cartoons? Do you see kid models or celebrities who appeal to kids or kid celebrities themselves? Is there kid-friendly music or language or activities inviting kids to participate in? If your site has some of these factors, it's possible, and maybe even likely, that your online service is directed to kids under 13, and you would need to comply with the COPPA rules. If your site is directed to kids under 13, you will need to provide notice and get prior verifiable parental consent before collecting, using, or disclosing kids who are under 13, so 12 and under kids, personal information. And by personal information, the statute means kids' first and last name, their home address, their email address, their phone number, their social security number, their geolocation information, so where they're located, where their server is, any videos or photographs that contain the child's image or voice. But there are a couple exceptions. One, I'm calling the cookies exception. So cookies or IP addresses, you don't need to get parental consent before collecting personal information for cookies, but only if the reason you're getting this information is to support the internal operations of your site or of your service. Another exception to the parental consent rule is if you're only seeking like a one-time response to a question. Here are some ways to obtain verifiable parental consent. First, you could have the child's parent, sign and return a consent form. They could fax it back to you. They could email it back to you or send it to you by some other electronic means. If there's a monetary transaction involved, you should instruct the parent to use an online payment system like a credit card that gives the primary account holder notice of each transaction. You could also set up a toll-free telephone number or a video conference number that parents could call, where they would talk to trained professionals who would then be able to confirm that they are actually talking to the parent of the child under 13 who is providing their personal information. You could also ask parents to submit government-issued IDs and then have your folks check those IDs against available databases. And only if the personal information is being used for your internal purposes, you could have them do kind of like an email plus type consent system, which is the parent would send you an email or you would send them an email, and then you'd require a second step, a follow-up phone call, a follow-up fax, a follow-up text to confirm that it's okay for you to collect and use the child's personal identifiable information. The last topic that I want to talk with you today, then I'll leave plenty of time for questions, deals with endorsements and reviews. So the FTC has published guides concerning the use of endorsements and testimonials in advertising. So what these guides do is that they provide rules and examples for advertisers as well as endorsers for using endorsements and testimonials in advertising. And the FTC treats the term endorsement and testimonial as the same. So a testimonial is an example of an endorsement. So where I've presented the definition of endorsement below, that also applies equally to testimonials. So an endorsement is any advertising message that consumers are likely to believe reflects the opinions, beliefs, findings, or experiences of a party other than the sponsoring advertiser, even if the views expressed by that party are identical to those of the sponsoring advertiser. And again, these guides apply to any advertising in any media, so TV, print ads, radio, social media, blogs, word of mouth, marketing, etc. Here's some general principles from the endorsement guides. If an endorser is providing an endorsement of your product or service, the endorser must provide his or her or their honest opinion. You as the advertiser can't use endorsements to make a claim that you couldn't legally make. So for example, if the endorser is talking about their experience and it's not verifiable by you, you can't use the endorser's endorsement. It's critical that the endorser use your product or service when the endorsement was given. So if you know, for example, that the endorser gave you a glowing review, but never in fact used your product or service, that would be misleading and problematic, both for you and for the endorser. Similarly, if the endorser stops using your product, Let's say you've signed up with an influencer or a celebrity. They've entered into an endorsement agreement with you for a year. And after a year, you and that person parted ways, and you know that that person's no longer using your products. You can't use the advertisements that were created during the term of your relationship with the celebrity after the fact. If the endorser is making claims about your product's performance, you need to make sure that there's substantiation, like we talked about before, exists. And the substantiation needs to be in existence before the endorser makes the claim. This seems to be an obvious next principle, but if you're using actual consumers in your ad, you actually should use people who use your product. Or if you're not, for example, you might see in some pharmaceutical ads on TV, they're using actors, but you'll also look in the fine print on your screen that the brands have clearly disclosed that the persons in their advertisement aren't actual consumers, they're actors, for example. If you are offering the endorsement of an expert, you need to make sure that that expert has sufficient expertise to offer the endorsement. What you can't do is present an endorsement by a consumer who is not a competent expert as an expert endorsement. So let's say you have signed up, you've received some endorsements of your product, either through a relationship that you and the endorser has started, or just naturally, someone tried your product, or you sent them a product to try. It is critical that the endorser disclose in their endorsement that there's a material connection between them and you, because the endorsement hopefully is going to cause other customers to purchase and use your product. So you need to make sure that the material connections is disclosed, because it will affect how consumers evaluate the endorsement, what weight that the consumer should give to it. For example, if you pay someone to endorse your product, the person who's endorsing your product should say something along the lines of, I'm paid by company X, or I received product from company X, or they sponsor me. It isn't required that you provide the person, the endorser, with a payment. Or let me put it to you differently. A payment does not trigger the disclosure requirement. If, for example, you wanted to build up buzz in your product or your service, and you know of certain influencers who might help you do that, you might send them, free samples of your product, or offer them to participate in your service, and hope that they will provide you with a glowing review. For celebrities, you might think that it's obvious. Everybody knows that Kim Kardashian, for example, endorses all these products, so a disclosure wouldn't be needed. That's not necessarily true. And neither you nor the endorser should assume that consumers know about, the endorser's relationship with other brands. It might be obvious, like something like Michael Jordan promoting Air Jordans, but that's more of the exception than the rule. This point is particularly important because if you don't disclose and the endorser doesn't disclose the material connection, both you and the endorser could be subject to liability. And there have been lots of cases where an endorser hasn't disclosed the material connection and they've had to pay some money, for example. We have about 5 minutes left, which I've set aside for questions. I'm going to try to stop sharing my screen and get into the question and answer tab to see, oops, if there are any. Oops. There we go. So Reet, I don't see any questions.
Hey, yeah. Okay, I think someone just posted one.
Oh, okay, great, thanks. Yeah, so Chris, thanks for your comment very much. Yeah, once, basically, in this concept, so Chris writes that they didn't know you can't use an endorsement once the contract has completed. So unless there are terms in your provisions in your contract that allow for the advertiser to continue to use the endorsement after the term of the contract ends, then you're right, you really need to stop. Similarly, if, for example, you come up with a new version of your product, you can't rely on an endorsement or substantiation, for that matter, from the earlier version if there has been a material change between the first version and the newer version. Just, oops.
Cool. Yeah, if anyone else has any questions, we'd love to hear them. Okay, I think we can maybe give it another couple seconds, but yeah, thank you, Lori, for all the very useful information about brand marketing here and the legalities. So I think, yeah, we're pretty much coming up on time, and it looks like we don't have any more questions. So we have a bunch of other really great content coming up later, so be sure to check the agenda and see all the other panels that are here. But thank you, Lori. Appreciate it.
My pleasure. Thanks.
All right.
Have a nice
Bye.
day. Bye.